statute, 607, says the president. I've got it in front of me, and so there is that.
Well,
let me just back up, though, just a second to what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yeah.
Did you agree that there are some core functions of the executive that President conduct that Congress cannot criminalize?
Yes.
Is that a form? I mean, we can call it immunity, or you can call it they can't do it, but what's the difference?
We call it an as-applied Article II challenge.
Okay. Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area you concede that an official acts that Congress cannot criminalize. And now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress because he objects to a piece of legislation that's going through. And it, in fact, delays the proceedings in Congress. Now, under 1512c2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word, euphemism you want to use for that? Or is that not core and therefore prosecutable?
Well,
without a clear statement that applies to the president?
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that the Constitution specifically allocates to the president. Once you get out...
So a president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain
Why?
the framework of why I don't think that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact
Well, I thought
pattern.
you said it, that was my question.
Yes,
and
I
you said
understand.
it fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. But there's a separate category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his Article 2.
He could have given speeches against it. He did.
Yes.
But he did something more, and it corruptly impeded and sought to influence an official proceeding.
Well, so I don't know. We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether...
Assume it does.
I will assume it. Then there's a question of whether he has the state of mind necessarily to violate
he does. Okay. Nobody knows what corrupt intent means. We've been around that tree
we will
twice
probably
already.
Find out.
And maybe it means that he knows that he was doing wrong, is what the government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be up there blocking a congressman from going.
Well, let me get to the next layer then, which is that the president does have access to the attorney general to provide legal advice and regularly gets legal advice from the Attorney General on the lawful scope of the President's activities. We could go down two tracks here. One is that the Attorney General advises him that as an incident of his Article II authority and in carrying out the functions of the presidency, he can lawfully participate in that protest. It's kind of the First Amendment analog to the President's official powers, which the court is exploring in other cases. Alternatively, the Attorney General could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it because you don't have to do that, and I would advise you not to violate the criminal law.
And then he could be prosecuted.
No.
No. If he gets a negative opinion from the Attorney General, he still couldn't be prosecuted?
I'm going to assume that most presidents are not going to take
but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we are down at that level, I think what we are really asking is whether the president is subject to the criminal law. And our answer is yes, he is subject to the criminal law.